Hi there, and welcome to the first of many episodes in the HALO webinar series. HALO, Hoosier Animal Law Officers, is Indiana's training organization for animal control officers, humane officers, rescue and foster personnel, and others within the animal care and control field. My name is Hannah Fisher, and I am the president of HALO. In this first episode, with an original recording date of January 17, 2020, we will discuss common animal-related laws within the state of Indiana. We will work through the definitions, the loopholes, the meaning and interpretation, and some of the other points made within the code and the application of these statutes. We hope that you get something out of this webinar and hope that the information is presented in a clear, concise manner for your understanding. As a disclaimer, this webinar and its videos, pictures, and other associated content has been compiled by HALO Incorporated. The information in this webinar is for educational purposes only and is not intended to provide a substitute for consulting with legal professionals. If you have a legal question or concern, we encourage you to contact your local prosecutor's office. We will open up the discussion of animal-related law with an explanation of how the criminal code is written. Frequently, you will see state statutes referred to as the IC code. This simply means Indiana Code. Commonly, people refer to the IC code as the criminal code, but not all of the Indiana Code is criminal offenses. And it makes it redundant by saying IC code, but that's how the majority of people refer to it. This is not to be confused with the IA codes that refer to Indiana administrative codes. We may or may not discuss those in future episodes, but for the most part, administrative codes are not relevant to our positions. In order to understand how IC codes are written, you must first be familiar with the acronym TAX. IC codes have 4 numbers. These numbers are written consecutively, separated by dashes. The first number refers to the title. Although there are multiple titles within the IC code, the one most commonly used by animal care and control professionals is 35. Title 35 as a whole refers to criminal law and procedures. Another example would be Title 9, which refers to traffic offenses, but that clearly isn't relevant for us. After the title comes the article. For most animal-related offenses, the code falls under Article 46, which refers to miscellaneous offenses. Other articles within the criminal law include sentencing, offenses against a person, theft and conversion, etc. Following the article comes the chapter. For the purposes of our jobs, we will work a lot with Chapter 3, which refers to offenses related to animals. And lastly, the 4th number refers to the section. This number pinpoints the exact offense. For example, Title 35, Article 46, Chapter 3, Section 1, as written here, refers to criminal title, miscellaneous offenses articles, relating to animals chapter, and the Section 1 of harboring a non-immunized dog. Another note regarding the reading, interpretation, and application code is to be very mindful of words such as and or, may and shall, and always and never. This can dramatically affect the interpretation and the application of the statute. We'll wrap up this portion of our discussion with a discussion of mens rea. Mens rea refers to the mental element of the person at the time the crime was committed. The literal Latin translation is guilty mind. However, as we know, our justice system must prove said guilt. There are 3 variations of mens rea that the Indiana Criminal Code recognizes. We'll continue on with that discussion in our next slide. Nearly every criminal statute will include a phrase such as a person who knowingly, intentionally, or recklessly, or a combination of some of those words, does such and such or doesn't do such and such. As an officer in the field, you don't need to have a law school level understanding of the difference between the 3, but you should have a general understanding. Recklessly simply refers to a person consciously disregarding an obvious risk or facts that they know will result in an undesirable or criminal outcome. It can also refer to a gross deviation from how a reasonable person would generally act under similar circumstances. Knowingly refers to a person who knows what they are doing, but they may not know the outcome, or they may not know that the outcome is unlawful. Intentionally generally refers to an action committed when a person consciously makes a decision with an intended outcome. Simply put, they freely choose to act, or in some cases not act, and know what the outcome will be. The primary difference between knowingly and intentionally is that with intentionally, they were trying to obtain the criminal outcome, or they were trying to obtain a certain result. In some states, and also in civil code, a 4th mens rea also exists. negligence. However, that does not appear in Indiana Criminal Code, so we will not discuss it. So as we learned, the majority of the time, the code that animal care and control professionals utilize is 3546.3. For the first few sections that we work through in this episode, I will articulate the title, article, chapter, and section. Then, once it is purposely redundant and annoying, we will just look at the language within the section, and I will discontinue walking through the title, article, chapter, and section. So let's get started. So we will start with section 0.05, which is the definitions that may be applied to this chapter in totality. So for this section, we are in Title 35, Criminal Law and Procedure, Article 46, Miscellaneous Offenses, Chapter 3, Related to Animals, and Section 0.05. We will work through the definitions in this chapter one by one. The definitions in this section can be applied to the other sections of the chapter as well. The full definition of abandon is written as, abandon means to desert an animal or to leave the animal without making provisions for adequate long-term care for the animal. The term does not include leaving an animal in a place that is temporarily vacated for the protection of human life during a disaster. Unfortunately, this definition has several built-in exemptions to abandoning an animal. The most commonly seen loophole is a person who tethers a dog to the front of a humane society or rescue that opens the next day. A defense can easily be built arguing that the dog was fine for the time overnight and that the offender knew the dog would be found and ultimately cared for when the business opened on that day. It is crappy, but it's an unfortunate loophole. Moving on to abuse, the definition articulates, beat, torment, injure, or otherwise harm an animal. Similarly, mutilate defines wounding, injuring, maiming, or disfiguring an animal, and damaging the body parts or rendering a part of the body useless. The definition for neglect is one that a professional in this field really needs to know. There are several subsections articulating what neglect is, and this is one of, if not the most, used definitions. So let's work through these subsections. First and foremost, neglect can refer to the failure to provide an animal food or drink. Note that it does not require constant food or constant water. Therefore, when investigating neglect cases, a person should look into the animal's body condition score and hydration levels. The Board of Animal Health sets guidelines for animal husbandry in terms of how much and how often food and water should be provided, but at the end of the day, if the animal is of an appropriate body condition and hydration level, it is not being neglected for purposes of this subsection. The second subsection of the neglect definition refers to the restraint of an animal. An animal that is restrained for more than a brief period in a manner that endangers the animal's health is possibly neglectful. However, what is a brief period? 5 minutes? 10 minutes? Half an hour? This is where your report, description of the totality of the circumstances, and discretion comes into play. I have filled one report out for charges in terms of this subsection. 2 dogs were left on tethers that were less than 10 inches long, overnight. So whereas someone could argue that 5, 10, or 30 minutes is brief, no reasonable person would argue that overnight is brief. However, in addition, I also refer to the lack of shelter and a few other factors to help paint the picture. So this should just be a tool in your tool belt, not necessarily a one-stop shop for proving neglect. The definition also refers to the length of the animal. Are we talking tip of nose to tip of tail, or neck to base of tail? Be sure that if you use this, it's fairly obvious. For the purpose of my case, a rope less than 10 inches was clearly less than 3 times the length of the dog's any body part. Other examples of inappropriate tethering include the tether that prohibits the animal to move freely or causes the animal to choke. Continuing on, we will discuss more definitions in this subsection. An animal can also be restrained in a manner that endangers its life or health without the use of a rope, chain, or tether. This could apply to the use of a crate, the conditions of a home, conditions inside a vehicle, and so on. Further elements of neglect include failing to care for or seek vet care for an injury or illness that seriously endangers life or health. A few concerns come along with this definition. First, the use of the words reasonable and seriously. What defines a serious endangerment to life or health? Does a chronic flea infestation causing open wounds from scratching constitute serious? Does dental disease that could become but hasn't yet systematic infection constitute serious? Again, using the totality of the circumstances when building your cases is crucial. Factor in the body condition, the general health, the living conditions, and any vet care that has or has not been provided. Additionally, it must be noted that this subsection only applies to dogs and cats. You have to be creative and use other prongs of the definition and/or other statutes when dealing with other species. One final prong of the neglect definition is the mention of exposure to outdoor heat and cold. Again, this one only applies to dogs and cats and uses the arbitrary word of excessive. Some local ordinances have been enacted to set specific temperature high and lows in which an animal must be brought in, but the state code is vague. However, in my personal opinion, this is best and allows for an officer to have discretion to evaluate the totality of the circumstances. For example, in general terms and for illustrative purposes, let's imagine it's a cold Indiana day, the temperature in the day averages around 15 degrees, and there's just a small amount of wind. You drive by a house and there are two dogs sitting on the porch. Dog A is an elderly 4-pound teacup chihuahua that up until this day has resided in its owner's climate-controlled house. Dog B is a healthy 3-year-old 100-pound Great Pyrenees that has been a working outdoor farm dog its entire life. Are the same concerns present for both dogs? No. But this does not mean to say that temperature restrictions should be based just on breed type. But evaluating a situation should consider the size of the animal, the age, the health, the environment which the dog is accustomed to, and so on. So again, to build a case using exposed to excessive temperatures as your winning argument, be sure you describe why for that particular animal the temperatures were or were not excessive. Moving on to the definition of torture, the state outlines 4 subsections for the definition. The first definition of torture is to inflict extreme physical pain or injury, and it has to have the intent of increasing or prolonging the animal's pain. The second subsection refers to administering poison to a domestic animal, or basically purposely exposing a domestic animal to a substance with the intent that the domestic animal ingests the substance. The next one is destroying an animal by electrocution. And then lastly, after an incident a few years ago, the state added intentionally freezing or heating an animal to death as torture. Moving to the next section, let's review tax. The next discussion is of Title 35, Criminal Law and Procedure, Article 46, Miscellaneous Offenses, Chapter 3, Related to Animals, and Section 1, Harboring a non-immunized dog. As I'm sure a lot of you know, rabies control is one of the founding principles of animal control. With it being such a fatal disease, and whether we like it or not, public health and safety being one of the top priorities, these laws are still on the books. Although technically a cat, ferret, or dog should be vaccinated, the criminal code only refers to dogs at this time. Harboring a non-immunized dog can be an infraction-level offense, fines, or a criminal offense, possible jail time. To enhance it to a criminal offense, there must be a bite with bodily injury. This is very easy to articulate. Even just one puncture that breaks the skin is bodily injury. When issuing your citations or filing the criminal offense, be able to articulate that the dog was over 6 months of age at the time of the incident. If you have vet records, include those. I've also used the line, when vet records don't exist, that through my training and experience, I knew the dog to be over 6 months of age. As with nearly everything within our job, we have discretion when it comes to some of these codes. A common approach I see when no bite is involved is to issue a warning or grace period for corrective action. Because after all, would we rather the money go towards paying a citation or go towards getting the vaccination? So for whatever reason, the state did not include 2 definitions within the definitions subsection that we just finished up. Those definitions are the animal fighting contest, which is defined as a conflict between 2 or more animals, and animal fighting paraphernalia, which is defined as equipment used to train or condition animals for participation in animal fighting. So with the animal fighting contest definition, it must be noted that this does not include a conflict that is unorganized or accidental. So basically what that means is if somebody's walking down the street and passes another dog and the dogs unintentionally get into a fight or an altercation, that's not considered animal fighting for the purpose of this statute. For animal fighting paraphernalia, this includes things such as spring poles, jennies, treadmills, things of that nature that are used to condition the animals for the animal fighting. Section 5 lists out the exceptions for the chapter. meaning these practices and activities, along with the full list under Section 5, are exempt from the requirements in the other sections of this chapter. Some of the common exceptions that you need to be aware of are fishing, hunting, and farming, veterinary practices, research facilities, pest control, destruction of an animal that is endangering, harassing, or threatening livestock, and destroying a person's property. One final one that most people are not aware of, but is an articulated exception within the state code, is the humane destruction of an animal a person owns. This means that if a person owns an animal, if it's healthy, unhealthy, aggressive, not aggressive, old, young, whatever the case may be, if the owner chooses to destroy the animal, they may legally do so if done in a humane manner. There's a lot of disagreement at this, but at the end of the day, you will see this occasionally used where a person destroys their own animal. As long as it was done in a humane manner, they cannot be held against cruelty or neglect or torture charges. Section 6 refers to the pre-conviction forfeiture statute of Chapter 3. We use this, or should be using this, for nearly every impound we do. This is a very important statute that, if you're unfamiliar with, causes huge headaches and can be confusing. But if you are familiar with it, it makes life so nice. Because of the importance of it, we will have a webinar episode solely on this section. Stay tuned for episode 2 in February. Section 7 is where we start to see the application of some of the definitions from Section .05. This section specifically focuses on abandonment and neglect. Refer to the supplemental material for the definitions from Section .05. In Indiana, abandonment and neglect refers to a vertebrate animal. A first-time offense is a Class A misdemeanor. This can be enhanced to a felony if the person has a prior unrelated conviction. Work with your local law enforcement and prosecutor's office to run things such as triple I's, which is a comprehensive background check, or other record checks to look for previous convictions. A defense that is built into this section is a reasonable belief that the animal could survive on its own. One example I think of for this is a feral or community cat. A cat of that nature has learned to survive on its own, so a person could easily maintain a reasonable belief that it could continue to survive on its own. Section 7 is the most commonly used statute that we see in animal care and control. A lot of the charges that we see and offenses that we see are related to abandonment and neglect. Again, be sure to know the definitions from .05 to apply to this section. So in Indiana, the animal fighting related offenses are based a lot on the totality of the circumstances and being able to prove a correlation between what is going on and your suspicions of animal fighting. That said, the first offense, Section 8, relates to the purchasing or possession of an animal for fighting. In this particular offense, you don't have to actively be using the animal for fighting, but if you can prove the intent of the person was to eventually use the animal for fighting, you could get this felony level charge. The second related offense is possession of animal fighting related paraphernalia. A lot of things related to animal fighting by themselves are not illegal, but if you can describe things and put everything together to present a package and prove that because of the circumstances and because of all of the other elements of the case, you could potentially get possession of paraphernalia charges. And lastly, in Indiana, you don't have to be the one actively fighting the animal or possessing the animal. Simply attending a fight or promoting a fight or in any way being involved in a fight is a felony level offense in Indiana. Section 11 includes some lesser seen offenses, but they are equally as noteworthy. They include cruelty to a law enforcement officer animal, a search and rescue animal, or a service animal. There are several prohibited acts within the statute, but it includes things such as striking, tormenting, or mistreating. There are enhancements for causing the death or serious injury of the animals, and there also is an articulation of interference with the actions of the animals. This means that even if a person doesn't hurt the animal, if they interfere, they have committed the offense. For the purposes of this section, search and rescue animal is only a dog that receives special training to locate or attempt to locate a person, with some specific examples and requirements built in. This subsection again discusses striking, tormenting, or mistreating, as well as interference. The last animal type is a service animal, and for the purposes of this section, it refers to an animal that a person who is impaired by blindness or visual impairment deafness or hearing impairment, physical disability, or a medical condition, and that they also rely on the dog for navigation, assistance with daily activities, or for alert signals. Similar violations exist for service animals, as with search and rescue or law enforcement animals. Service animals and emotional support animals are a very hot topic right now in the animal world. We will be conducting future trainings specifically on these topics. Section 12 is the application of the definitions we learned for abuses, tortures, or mutilates. So refer to those definitions when applying them to these offenses, but these offenses can be a Class A misdemeanor with enhancements up to a Level 6 felony. A second part of this subsection refers to knowingly or intentionally killing a domestic animal without the consent of the owner. It must be noted for this specific subsection there are restrictions on species, and not all vertebrate animals are included. This offense, if it is a domestic animal that is included in the subsection, is a Level 6 felony. So Indiana now recognizes the strong link between animal cruelty, domestic violence, crimes against children, and crimes against person in general. So a few years ago, they enacted this new subsection related to domestic violence. So now it is a felony level offense for a person to knowingly or intentionally kill a vertebrate animal if the intention is to threaten, intimidate, coerce, harass, or terrorize a family or household member. A person who knowingly or intentionally removes the vocal cords of a trained attack dog commits cruelty to an animal, a Class A misdemeanor, which is offense under subsection 13. In terms of decompression of an animal, a person who knowingly or intentionally destroys or authorizes the destruction of an animal by placing the animal in a decompression chamber commits a Class B misdemeanor. Exceptions to this offense include a state or federally inspected livestock slaughtering facility, an animal disease diagnostic lab, a post-secondary educational institute, or a research facility licensed by the USDA. So Indiana has a relatively comprehensive statute when it comes to bestiality, and defines bestiality basically as any act performed involving a human mouth, anus, or sex organ and an animal's mouth, anus, or sex organ. These offenses are a Level 6 felony. However, some things that are not included in the bestiality statute, which you may find yourself investigating, are offenses related to digital penetration by use of fingers, the use of sex toys and foreign objects, frottage, crush films, and masturbation. Crush films are covered under federal law now, but they are not specifically included in the state code. So in investigating cases like this, it's important to document everything and possibly refer to some of the other statutes we discussed as far as abuse, torture, mutilate, and neglect. Outside of 3546.3, there are some other chapters and titles in which you will find animal-related offenses. In this presentation, we will include a few, but this is not a comprehensive list. These will help you with miscellaneous concerns and topics and offer you some creative solutions to situations that you may run into. The first miscellaneous offense we will cover is 1521.4, which is related to dog bite liability. It's a Class C misdemeanor for a person to recklessly, knowingly, or intentionally fail to reasonably restrain their dog, the dog enter another person's property, and the dog then bite and attack without provocation. Like I said, it is a Class C misdemeanor, however, it can be enhanced up to a Level 5 felony related to things such as the seriousness of the bodily injury and/or death caused by the bite or attack. The other subsection within Section 4 is subsection C, which reads, an owner of a dog commits a Class D infraction if the owner of the dog allows the dog to stray beyond the owner's premises, unless the dog is under the reasonable control of an individual, or the dog is engaged in lawful hunting and accompanied by the owner or custodian. However, please note the exceptions within the subsection. Recently, I had a conversation with a local DNR officer about a non-aggressive dog being on agricultural or forested land. That in itself is an exemption, as in a dog that is lawfully involved in hunting. However, for the most part, you can use this subsection as a state-level offense of running at large. If you can articulate that at any point the dog was on land other than agricultural or forested land, for example, a public roadway or someone else's property, you could cite the owner for this offense. This statute is similar to IC 35-46-3-5. As you may recall, that list of exceptions included the killing animals that are destroying livestock or damaging property. It is important to note that in this section, the dog must be in the act of killing or injuring the livestock, and thus, if a dog attacks a cow today and the farmer shoots the dog tomorrow, this may not cover them. In addition to the act having to be in progress, the person killing the dog must also have the consent of the person who owns the land in which the dog and livestock is on. For a multitude of reasons, with one of the top reasons being environmental and public health concerns, a person who owns or cares for an animal that has died from any cause shall dispose of the animal's body not later than 24 hours after knowledge of the death so as to not produce a nuisance. Note that this does not apply to dead fish, reptiles, small animals, including dogs, cats, and game. This primarily refers to livestock and horses and things of a larger nature. Improper disposal or failure to dispose of a dead animal can be a level 6 felony. So let's do a quick recap of what we've learned today. First and foremost, IC refers to the Indiana Code. The Indiana Code spells out the criminal and infractional level offenses within the state. Within the code is written with the acronym TAX. The codes are written with 4 numbers. The first number refers to the title, the second number refers to the article, the third number refers to the chapter, and the last number refers to the section. Several animal-related offenses are condensed in one chapter, 3546-3. Several other animal-related offenses are scattered throughout the code. And lastly, creativity can help build cases. If you know it's wrong, it probably is wrong, and you can find a code for it somewhere, either in Chapter 3 or in the other offenses that we've discussed. Thank you for taking time out of your busy schedule to follow along in this webinar. If this was a new topic for you, I hope you now have a foundational understanding of the material. If this was a refresher for you, hopefully you learned at least one new thing. We at Halo appreciate all that you do for the animals in the state of Indiana and the animal care and control field. Please like us on Facebook at Hoosier Animal Law Officers, check out our website, HoosierAnimalLawOfficers.org, or reach out to us directly if you have questions, concerns, or ideas for training. Thanks again, and stay safe.